Hello everyone, I'm Ankit and this is StudyIQ IAS. Now these days, especially the Indian Express, it is filled with articles highlighting the important Supreme Court judgments in the past. And today there was this article which brought my curiosity. It was on Shankari Prasad case, which was a judgment given by the Supreme Court back in 1951. But to understand what this judgment entails, we have to go back in time by understanding what is the process of Zamindari system in India. Now this practice of Zamindari system, it started during the British rule. As British government, it delineated the large tracts of land and handed it over to a section of people known as Zamindars, which roughly translates into landlords. Now these Zamindars, they were responsible for collecting taxes on those lands from the farmers that were growing crops on these lands and ultimately passing on these taxes to the British government. Also, these zamindars, if they were to make any surplus money, they can keep it with themselves. Now, over decades, this process became quite an exploitative process. As these zamindars, they used to extract large amount of taxes from poor and helpless farmers, and that is why the state of agriculture in India, in addition to the condition of farmers, they were a very sorry state. So this practice of exploitative zamindari system was one of the first policy priorities of the independent government of India, that it wanted to do away with this entire practice in its eternity. And as a result, as soon as India got independent, the independent governments of both central as well as state governments, they decided a way to abolish this practice of zamindari system and introduce a series of legislations that were called as land reforms. So at today's discussion around Sankari Prasad case deals with the abolition of Zamindari system. Now as I told you, as soon as India got independent, central as well as state governments, they brought many pieces of legislation that ultimately wanted to end this Zamindari system. Similarly, even the Bihar Legislative Assembly passed an act which was called as Bihar State Management of Estates and Tenures Act 1949. Now as soon as this act was passed, the zamindars of Bihar, they went to the Patna High Court protesting that this act was actually unconstitutional. And highlighting that concern, Patna High Court, it actually invalidated and made this act as an unconstitutional act, which made this act as a void act. Now the reason that the Patna High Court cited so as to make this act as an unconstitutional act, that it took away the right of equality, which is a part of fundamental rights of the landlords. As the compensation that the government provided to these landlords when they took their lands away, according to Patna High Court, it was not a just compensation. And any measure by the government, if it takes away the fundamental right of any of the Indian citizen, it can be deemed as an unconstitutional act. So the fight between government and Zamindar scored the first goal, that is, they sought victory over the government just because the Patna High Court passed a legislation or passed a judgment which declared such measures as an unconstitutional measure. Now, before even challenging this act in higher courts, the Pradhan Mantri of that time, that is Prime Minister Jawaharlal Nehru, he brought the first amendment to the Indian Constitution, which made many changes into the Constitution. But for our today's discussion, two changes were very important. First, that this amendment introduced Article 31A, and the second was that it introduced a newer article, Article 31B. So what does these changes actually tries to bring? Now Article 31A, it was introduced into the Indian Constitution and it stated that any land acquisition law which was made to implement land reforms, they will not be deemed as an unconstitutional and void just because of the fact it took away the fundamental rights of the landlords. So that is why in one scoop, the zamindars will not be able to claim in the courts that their fundamental rights were violated by the land reform measures. Additionally, by Article 31B, the Constitution introduced the provision of 9th schedule into the Constitution, and if any law or legislation it were to be inserted in this very 9th schedule, that made that particular piece of legislation immune to be considered by courts. So any of the legislation which is implemented or put forward into the 9th schedule cannot be challenged into any court of the law. So these two measures was what was implemented by the First Amendment Act. And against this very First Amendment Act, Shankari Prasad went to the Supreme Court of India. As according to him, The First Amendment Act, it was void or unconstitutional based on two circumstances. First was that at that time India did not have a constitution and it was a provisional parliament that was in function. So according to Sankari Prasad, it was not in the power of provincial parliament or a provisional parliament to amend the constitution in the first place. And even if the provisional parliament had the power to amend the constitution, it cannot take away or introduce any amendment that takes away the fundamental rights of the citizen. Because originally Article 13 subsection 2 of the constitution, it provided the fact that any law or legislation or an amendment of the constitution, if it were to take away the fundamental right or alter it, it was actually to be considered by the court and ultimately to be struck down by the court. So according to Shankari Prasad, these two were the logical arguments that actually invalidated the First Amendment Act. So what did the Supreme Court say about it? The Supreme Court actually took the side of the government in this regard. And a judgment which was delivered by a 5-judge constitution bench of the Supreme Court, it highlighted or it said that there is a clear demarcation between the two powers of the parliament. First is the legislative power, where parliament can pass any law. And the second is called as constitutional power. That is, under the constituent power of the parliament, it can amend the constitution. So if any law is passed by the parliament under its legislative powers, then the parliament cannot take away the fundamental right. But when it comes to its constituent power, if it were to amend the constitution, then the parliament had unlimited power to make any changes of the constitution, including taking away or removing the fundamental rights in its entirety. So according to Supreme Court, in the Shankari Prasad judgment, it said that the parliament under its constituent power had the unlimited power to amend anything in the constitution. So is currently the parliament having the unlimited power to amend the constitution? The answer is not. Why? Because there was this another significant judgment that was passed in 1973 known as Keshwananda Bharati Act. And in this judgment, which was passed by a 13 judges bench, which was the highest amount of bench that has ever been heard a case in the Supreme Court, this particular judgment highlighted that the parliament did not have the unlimited power to amend the constitution. Rather, parliament, it was limited by amending only those provisions of the constitution that did not amount to the foundational principle of the constitution. And it gave a term to these foundational principles called as basic structure. So according to Supreme Court, as per the Keshwananda Bharati Act, the parliament has the power not to amend the basic structure of the constitution, which in subsequent judgments, Supreme Court has highlighted that fundamental rights is a part of basic structure of the constitution. So when it comes to amending the fundamental rights in its entirety, the Supreme Court or the Parliament of India does not have an unlimited power. But what about right to property? Right to property, according to the Supreme Court of India, it does not constitute the basic structure. Therefore, Supreme Court or Parliament, it has the power to take away the right to property, whereas fundamental rights are concerned, these are part of basic structure and hence they are not amendable. Understood? So this was the implication of Shankari Prasad case. And why are we dealing with this case today? Because important Supreme Court cases, particularly IR Coelho case, was asked in the mains examination in 2016. So similarly, as these cases are in news, you can expect a similar question in this year's mains. So this was all from my side for today. Please stay tuned to our YouTube channel for more such informative videos, and until then, I'll take your leave.